inspiration,
passion,
balance,
ideas,
innovation,
productivity,
power,
creativity,
growth,
results,
excitement,
positivity,
success.
Good afternoon, Christine Kepp here, new agent mentor for Realty One Group Southwest. The purpose of this video is to familiarize you with the content of the California Residential Listing Agreement, Exclusive Authorization and Right to Sell, Form RLA, and to discuss how to fill it out correctly. We're currently in the section of the program where we are discussing working with sellers. Learning how to work with the residential listing agreement, how to fill it out properly and get it signed will be vital to your success as a real estate agent. As I go through the agreement in detail, make sure to follow along on your printed form and make notes as needed. So let's jump right into Section 1. In Section 1, list the name of all sellers. In most situations, the seller should be the owners of the property, the persons who intend and have the authority to both list and sell the property. Best practice would be to obtain a property profile for the subject property before your listing appointment so you know who is currently on title. You can do this by logging on to the MLS and clicking the Realist Tax tab. You will then see a page that will allow you to search by name or by address. Enter the search criteria and it will then pull up the property profile. Look under owner information for the names of who is currently on title. Insert the name of the listing broker. The seller enters into the listing agreement with the real estate broker or brokerage, not with you, the individual salesperson or broker associate. Insert the calendar date the listing period will begin. This date will typically be the date you and your client enters into the listing agreement. However, there are certain circumstances where the listing will begin at a later date, for example, when waiting for a prior listing agreement to expire, or when the seller needs to prepare the home for sale. Insert the calendar date the listing period will end. You always want to fill in the blank with an ending date. According to California Business and Professions Code, Section 10176F, a listing agent cannot claim, demand, or receive a commission under an exclusive listing agreement unless the agreement contains a definite, specified date of final and complete termination. Determining the proper length of time for a particular listing requires careful weighing of several factors, such as the listing price, the condition of the property, the party's requirements, and market conditions. If the listing period is very short, such as 30 days, you may spend a lot of time, money, and effort to market a property, yet not find a buyer nor earn a commission within the specified time frame. On the other hand, if you attempt to insert into a lengthy listing period, such as 12 months or more, the seller may refuse to enter into the listing agreement. Next, you want to insert the name of the city where the subject property is located, also the county where the subject property is located. You want to insert the assessor's parcel number, which can also be located on the property profile. Insert the street address of the subject property. In Section 2, you will list any and all items of personal property to be included and excluded in the sale. This section states that all fixtures and fittings are included in the sale and all personal property is excluded unless otherwise specified by the contract. Whether an item is a fixture or personal property is a question of fact to be determined on a case-by-case basis and can often be confusing when it comes to items such as custom-made drapes. When in doubt, simply list any and all items the seller wants to include in the sale, such as appliances, custom-made items, fountains, and small sheds. And list anything attached to the property that the seller wants to exclude from the sale, such as family heirlooms, chandeliers, and antique fixtures. Here is a best practice pointer in regard to personal property and fixtures. When an offer is received and the buyers have not inserted the excluded items set forth in the listing agreement, you as the listing agent should, with the seller's consent, exclude those items from the sale using a counteroffer. Simply itemizing certain things on the listing agreement does not mean that they are incorporated into the terms of the purchase contract. In Section 3, write out the listing price using words and in the parentheses after the $sign using numbers. The listing price is a target price in the sense that if a ready, willing, and able buyer offers to buy the property for the listing price and other terms set forth, the broker earns his or her commission. Hence, the listing price is usually what the seller is willing to sell the property for. Moving on to Section 4 of page 1, let's discuss compensation to the broker. The notice at the beginning of the section states that the amount or rate of real estate commissions is not fixed by law. It is set by each broker individually and may be negotiated between seller and broker. According to California Business and Professions Code, Section 10147.5a, this notice must be set forth in not less than 10-point bold-faced type on any printed or standard form agreement establishing or altering a listing agent's right to compensation in the sale of 1 to 4 residential units. Because of this font size requirement, be sure not to reduce the size of the document, for example, when using a copier before the seller signs it. The broker's commission can be expressed either as a percentage or as a flat fee. Check the appropriate box and insert either the commission rate or amount. Keep in mind that in accordance with California Business and Professions Code Section 10147.5b, for 1 to 4 residential units, the broker should not preprint the commission rate or amount. The subparagraph under 4A2 is the safe harbor provision. To avoid paying the broker's compensation, a seller may be tempted to reject an offer from a buyer procured during the listing period only to sell the subject property to the same buyer after the listing period ends. The safe harbor provision reduces the possibility of this type of unfair dealing in protecting the broker's compensation for a certain number of days after the listing period ends. The safe harbor provision, however, has 2 limitations. First, it only pertains to prospective buyers who, during the listing period, physically entered and were shown the property, or those who submitted written offers to the seller. The broker is not protected if the property is sold to anyone who does not fall into these categories. Second, the safe harbor only applies if, within 3 calendar days after the listing period ends, the broker provides the seller with a written list of the names of these prospective buyers. Just as with determining the length of the listing period, determining the proper number of safe harbor days requires a weighing of various factors as well. If the safe harbor period is too short, such as 30 days, the broker has very little protection. On the other hand, if the broker demands a lengthy safe harbor period, such as 12 months, the seller may not give the listing to the broker. Under 4C, list any other costs to be paid by seller other than the compensation set forth above. Other costs to be paid by the seller could include MLS fees, advertising fees, or other costs for marketing the property. If there are no other costs to the seller, insert NA to demonstrate to the seller that there are no additional fees. Under 4D, you should insert the amount of compensation that the broker will offer cooperating brokers through the MLS as a percentage of the purchase price or as a flat fee. The purpose of Section F is to identify any other listing agreements the seller has entered into with another broker regarding the property. Before entering into a listing agreement, a realtor has an affirmative obligation under the NAR Code of Ethics to make reasonable efforts to determine whether a prospective client is subject to a current, valid, exclusive agreement to provide the same type of real estate service. Even if a listing period has ended, a seller who has a listing agreement with broker A will not want to enter into a listing agreement with broker B during broker A's safe harbor period. Otherwise, the seller risks being obligated to pay full commissions to both brokers if a buyer procured during broker A's listing period subsequently buys the property during both broker A's safe harbor period and broker B's listing period. To avoid this result, subparagraph 4F allows the seller to exclude prospective buyers procured by broker A from broker B's listing agreement. Broker B will not receive any compensation if anyone on this list buys the property. A best practice pointer if you are in broker B's position would be to carefully review the terms of the seller's listing agreement with broker A and verify that broker A's list of prospective buyers has been timely and properly submitted to the seller. Also, if broker A's safe harbor period ends before broker B's listing period ends, broker B may want the exclusion to terminate when broker A's safe harbor period ends. For example, broker B takes a listing from January 1st to March 31st, but broker A's safe harbor period for certain buyers ends February 28th. Broker B may want to exclude these buyers until February 28th only and not for the full duration of broker B's listing period to March 31st. In 5A, enter the multiple listing service in which the property will be listed. If it will be listed in an MLS that is not the primary MLS for the geographic location of the property, then check the box on line 2. This next section explains to the seller the benefits of using the multiple listing service, the impact of opting out of using the multiple listing service, and it explains that the seller understands that the broker must present all offers received unless the seller gives the broker written instructions to the contrary. When obtaining signatures from the seller, make sure to pay attention to the initials in this section as they are often overlooked. Section 5B states that a broker must submit a listing to the MLS within 2 days or else submit form SELM in its place, which is seller instruction to exclude listing from the multiple listing service. Section 5C deals with listings being syndicated out to other internet sites. If a seller does not want the listing to be syndicated, they must sign form SELI, which the broker then submits to the MLS, and that form is seller instruction to exclude listing from the internet. On this next page, page 3, the section where it says deposit states that the broker is authorized to accept and hold on seller's behalf any deposits to be applied towards the purchase price. However, best practice is to have all deposits held in escrow so you don't have to deal with any trust fund issues. Under Section 9, Agency Relationships, note that prior to entering into the listing agreement, you must have the seller sign a disclosure regarding agency relationship CAR Form AD and make sure that the seller receives a copy. At the bottom of page 3, under Section 11, Photographs and Internet Advertising, only check the box in Section A if the seller objects to having photographs or images taken of their property. Under Section B, check the box only if the seller instructs the broker to publish in the MLS that the taking of images will be limited only to those preparing the appraisal or inspection reports. Under Section 12 at the bottom of page 3, check the box if the seller does not authorize the broker to install a lockbox on their property. We are now on the 4th page of the residential listing agreement. At the top of the page, under Section 13, check the box only if the seller does not authorize the broker to put up a for sale sign at the property. Under Section 16, Additional Terms, check the appropriate box if the listing is either an REO or a short sale. This is also the place to put any additional terms that were agreed upon for this listing. At the bottom of page 4 in Section 19 is Dispute Resolution. Section A, Mediation, states that the parties agree to mediate any dispute arising out of the listing agreement, with certain exceptions set forth in paragraph 19C below. Mediation is required even if the parties do not place their initials in this paragraph. Mediation entails an attempt by a neutral third party to help the contractual parties voluntarily resolve their differences. If the parties agree to a certain resolution, the mediation succeeds. If the parties do not agree, the mediation fails and the parties must now resolve their dispute through arbitration or litigation. If a party commences a legal action without first attempting mediation pursuant to this provision, that party is barred from recovering attorney fees. Under Section 19B, Arbitration of Disputes, both parties must insert their initials for the arbitration clause to apply. If properly initialed, the parties agree to submit to binding arbitration for any disputes arising out of the listing agreement, which is not settled by mediation, with certain exceptions set forth in 19C below. The notice must be set forth in at least 10-point boldface type for an arbitration agreement to be enforceable. Therefore, you want to be careful again when making copies of the listing agreement for signatures. Arbitration is an alternative dispute resolution to the court system. The parties submit their agreements and evidence to an agreed-upon arbitrator rather than a judge or jury. The arbitrator shall render a decision. The arbitrator's decision or award can only be set aside by the losing party in very limited circumstances, such as failure of due process, fraud, or corruption by the arbitrator. Otherwise, the prevailing party can have the arbitrator's award confirmed as a judgment in any court having proper jurisdiction. Determining whether arbitration is a better way to resolve a dispute as compared to the court system may entail legal options. Therefore, the broker should not advise the seller to initial or not initial the arbitration clause, nor should the sales agent or broker associate. To help the seller decide how to handle the arbitration clause, California Association of Realtors provides a legal publication entitled Arbitration for the Consumer, and that's available online at the following web address. We have now made it to the fifth and final page of the listing agreement. By signing the listing agreement, the seller acknowledges that he or she has read and understands the agreement and has received a copy. The seller should insert the date of signature and provide an address, phone number, fax if available, and email address. The seller should also initial the bottom of the pages 1 through 4 of the listing agreement. This section has space for 2 sellers to sign. However, in most situations, all owners of the subject property should sign the listing agreement. Thus, if there are additional sellers, you may use California Association of Realtors standard form Additional Signature Addendum, Form ASA, as an additional signature page. The salesperson or broker or associate taking the listing can complete the broker's information and sign as authorized representative of the broker. However, no one should sign the listing agreement until all pages have been completed, and in accordance with California Business and Professions Code, Section 10142, the listing agent should deliver a copy of the agreement to the seller at the time the signature is obtained. Aside from filling in your BRE license number in this section, you will also have to fill in Realty One Group Southwest's broker's license. That can be found by logging into MyRog, going to the Forms section, choose General Information, and on the close to the bottom right hand side you will see the broker's license number. Next, we're going to briefly discuss a seller's advisory, which is part of the residential listing agreement. This is an important tutorial for the seller. It is helpful to have the seller read and sign the advisory prior to filling out the listing contract because it explains disclosure obligations, contract negotiations, and marketing considerations. The purpose of the seller's advisory is to make the seller aware of these issues early on, thereby encouraging the seller to identify and resolve potential problems as soon as he or she can. So I have one last best practice pointer for you before we wrap things up, and that is to give your clients the California Association of Realtors Property Transaction Booklet when you have them sign the agency disclosure. This pamphlet covers a lot of issues regarding the importance of proper disclosure and other frequently asked questions sellers may have regarding disclosure issues. So that concludes our review of the residential listing agreement. Thank you so much for your time, and as always, should you have any questions, comments, or concerns, please feel free to contact me. Thank you so much.